Welcome to our project, Voice. In order to execute our project, we're doing several videos, one of which is an interview with two police sergeants in Port of Spain. Here's what they had to say about domestic violence in Trinidad and Tobago and their experiences with it.
I'm Sergeant Rajesh Lal, Port of Process Prosecutor, First Court Magistrate.
I am Acting Inspector Sean Sukram.
Most of the time it's under sub A, which is the spouse of the respondent, and it continues, a member of the household of the spouse. It continues that section 4, sub 4, a police officer, a probation officer, or approved social worker can also apply for a protection order. Court shall grant a protection order where it is satisfied A, that the respondent is engaging in or has engaged in domestic violence against the applicant, or B, is likely to engage in a conduct that will constitute domestic violence. So it's a very simple process in which a person can make an application for a protection order. You first of all, you make the report to the police station. This gives you evidence before the court that a report was made. If a medical is obtained, it even supports your claim even further. You go to the Justice of the Peace at the magistrate court in your district, and they will make an application. You make the application. It costs under $10. That application now has to be served on the respondent. That's free of charge. You carry the summons to the summons officer. You find out who the summons officer is in the station, and he will then serve it upon the respondent. And then the respondent has to appear before the court. It is your right to have an attorney, which may cost money, or you could apply. The court would hear both sides. The court is fair, they will listen to both sides. You carry all your reports or any medical that could support that you are indeed a victim of domestic violence, and the court would weigh both sides as again balance the probabilities, and an order will be made against the person once the court is satisfied. You speak the truth, there's nothing for you to hide, and you have the evidence. It's even better for the court to determine, and then the order is served on the respondent, and you hand the copy of the order to the police station that you live in, so they would be aware of the order. You must always keep your copy, and as again, there's no cost attached to those things. And once there's a breach, you call the police via 999, via the station number, they respond, the person immediately arrested.
There is that interim order based on your first report, where the court issued that what we call an interim protection order. And as where both parties are now required to come to court, that's within the 14 days.
Yes.
Right? Usually that's for 14 days. And when you would have satisfied the court, you are then given that final order. In most cases, that final order runs for a 3-year period. And if after that 3 year you think you still need, then you may apply for a fresh one. So there's that interim order and there's that final order. The interim is usually a 14 days from your first report to the court, and then we go into that final order, which lasts for about a 3-year period.
And the court even gives the option, or the law gives the option of varying the order. So if there has been compliance with counseling or the instructions the court has given, and there has been an improvement in the relationship, and in relation to having children and conveying children, because those are the instances, staying away apart and all these things, the person, the applicant, or even the respondent could have the order varied to reduce or increase some of the restrictions. These are the offences. On a first conviction, to a fine not exceeding $9,000 or imprisonment for a period not exceeding 3 months. A second conviction, to a fine of not exceeding $15,000 or imprisonment for a period not exceeding 24 months, so up to 2 years. And on a subsequent, to a period of imprisonment not exceeding 5 years. So you realize if there's a third offense, there's no fine to be paid. It's imprisonment one time.
While these things are there, these are not the solution to the problem. These are not the solution. Whilst it may give you a physical, if the person is incarcerated, there's that physical bit of protection for the period, but what happens after? So this is not the end all to the situation that brings about a protection order, but it is the best that can be done in the circumstances with the court or through the court. These orders are breached quite frequently because the order, the conditions, the prohibitions, they vary. Sometimes persons are restricted from coming within 100 meters of the applicant. Sometimes you are restricted from visiting their workplace, not to use any threatening language, obscene language, not to assault and so on. So the conditions of the protection order varies, and quite often, because although in the first place there was a protection order because there was a problem between the parties, oftentimes they do not reach the stage of solving the problem. So you have a piece of paper between you and I with some prohibitions, but that doesn't solve our problems. So one party may wish to talk to the other party, and simply by visiting home, you would have breached the order because you come within 100 meters. There is that perception, but it does not really make our job harder, because our job really begins when they come forward and make that report. However, the problem that led to is that it causes the violation to continue. So it doesn't really affect policing per se and how hard our job is, but the longer you take to come forward, the longer the crime is going to continue and be perpetrated against you.
When a police officer, while on patrol, hears something or something is reported and they have reasonable cause to believe that something is being done in relation to domestic violence, the police have the powers to enter that premises and take action.
If you wish to have problem dealt with, then you really need to take that first step. By coming to us, we can facilitate the entire process. That may simply be getting some form of counseling, and it can stop there. Or if it means taking it to the court, we will do that, and then the court can exercise whatever option the court thinks fit. But certainly the perception that we cannot help is not a right perception, it's a wrong perception. But we can definitely facilitate, and once persons do come forward and make that report, we will do all that we can to treat the case.
Persons have a taboo as it relates to making a report against their wives, and they feel that the police would laugh at them. It is a very serious matter, because a lot of times some men are victims.
We have to encourage men to appreciate the fact that you are a human being and your person ought not to be violated. So if it is that you are being abused or violated in some way, you need to reach out to someone, be it a priest, a friend, a family member, counselor, or they just walk into one of the government agencies like social services and ask to talk to somebody. There are mental outreach centers in different communities, or they just walk into there and reach out to someone. But certainly, it needs to stop. It needs to stop. So you have to find that courage. Well, certainly we would want to encourage victims to find that inner strength and courage to take that first step, whether that step be coming to the police or any other person who can make a report on your behalf. We implore you to find the strength and the courage to take that first step on that